Ben Meiselas and Michael Popok here from LegalAF. Here is our takeaways from that DC Circuit Court of Appeals oral argument on Donald Trump's appeal on the issue of absolute presidential immunity. I just want to go to the heart of it to put these two clips that I think tell the whole story. Then, Popok, I want to get your summary of what went down. First, Donald Trump's lawyer, John Sauer, being questioned by the panel on the DC Circuit Court of Appeals, specifically Judge Pan, about whether or not, under Donald Trump's view of absolute presidential immunity, a president could order things like SEAL Team 6 to kill a political rival, call it an official act, and claim absolute presidential immunity. Watch what went down.
Order SEAL Team 6 to assassinate a political rival. That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is
no. My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders were much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist Number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked.
Okay, and the court continues to grill Trump's lawyer, John Sauer, on that. Compare that, though, Michael Popok, to the lawyer arguing on behalf of the government, James Pierce, who brought up this issue as well. Watch this.
Based on questions of separation of powers, of constitutional text, history, precedent, is there, in fact, immunity for a former president? We think the answer to that is no, for of course, all of the reasons we put in the brief, and I'm happy to sort of address here. Candidly, I think if the court gets to that second question, there are some hard questions about the nature of official acts. And frankly, as I think Judge Pan's hypothetical described, I mean, what kind of world are we living in if, as I understood my friend on the other side to say here, a president orders his SEAL team to assassinate a political rival and resigns, for example, before an impeachment? Not a criminal act. President sells a pardon, resigns, or is not impeached? Not a crime. I think that is extraordinarily frightening future, and that is the kind of, we're talking about a balancing and a weighing of the interests, I think that should weigh extraordinarily heavily in the court's consideration.
So, Michael Popok, tell us, how did we get here? What'd you think of the DC Circuit Court of Appeals panel, their questioning? Break it down for us.
Yeah. And thanks, Ben. First of all, as you and I predicted on our last LegalAF, it was Judge Pan, a recent Biden appointee, who took the lead here. I think she was probably, if she wasn't the kind of the chief judge for the 3-judge panel today, she certainly acted like she was, and she was certainly loaded and ready right from the get-go. Before we get to the heart of the SEAL Team 6 example, which I think actually killed, and I wrote you at that time, killed the case for former President Trump at that moment because of the lack of candor and just kind of an unreasonable position that his lawyer, John Sauer, took in response when he finally answered the question after being told 3 times by Judge Pan, you're not answering my yes and no question, yes or no. You're giving me some conditional yes. This is the question. If there is no impeachment process that led to a conviction of the then president, And he did the things that I just outlined, ordering that SEAL Team 6, which he's allowed to do as an official act, ordering them to take out a political rival. Your position is that that person can't be, that president for that act can't be criminally prosecuted outside of the Senate or the House. Is that your position? He finally had to concede that it was yes. And at that moment, that's where he lost the panel, I believe, certainly Judge Pan, and I think the 3 votes. How did we get here? Judge Chutkan made a very well-reasoned decision, the trial court judge, several weeks ago, in which he found no immunity would apply to Donald Trump's indicted conduct as laid out in Jack Smith special counsel's indictment, the 4 counts against him. And at the beginning of the case, certainly there's not going to be there shouldn't be a dismissal of the indictment based on immunity grounds. That went up on appeal first to the 3-judge panel of a random 3-judge panel assigned by the DC Court of Appeals. Jack Smith threw a little bit of a gambit. He thought maybe he could take a direct line directly to the U.S. Supreme Court. And they said, no, go down to the lower court first. We like our cases coming up the old normal old-fashioned way from the lower level court. And we had full briefing there that you and I reported on, along with Karen, our colleague, about all the issues. And so coming in, the panel was also this 3-judge panel of Henderson, a G.W. Bush appointee, Michelle Childs from South Carolina, who was pushed, if people recall, by Lindsey Graham to be on the U.S. Supreme Court, but is now taking some time here at the D.C. Court of Appeals, and Judge Pan, also appointed by Joe Biden, heard these issues. And there was a brief that was filed by what we call Friends of the Court, which are learned scholars coming from, in this case, Republicans, who wrote a brief saying, you don't even have to get to the issue, the substantive issue, because you don't have jurisdiction as an appellate court, because this appeal is too early in the case. It's called interlocutory, meaning we haven't even tried the case yet. There hasn't been a jury verdict or a sentencing, and so the court doesn't have jurisdiction. And they were very concerned at the very beginning. The first question out of the box by Judge Pan, then followed by Judge Childs, was, do we even have jurisdiction based on the case law, one of these asphalt cases written by Scalia? Maybe we don't have jurisdiction. And I gave a lot of credit to James Pierce, the lawyer for the Department of Justice, because he said, we understand that argument. We just don't think it's applicable here. And we think that the proper thing for this court to do is to make a substantive ruling as to whether there is presidential immunity, as outlined by Donald Trump, for him committing crimes as alleged in the indictment or not. And we don't want to take the shortcut of, this is my words, a shortcut of arguing on a technicality that there isn't jurisdiction. He got saved. The issue got saved a bit by Judge Pan when she reminded everybody that there is a way, as long as the jurisdiction is statutory and not Article 3, dealing with how federal judges get their powers to hear cases, that you can still have basically temporary jurisdiction or jurisdiction for the purposes of rendering a substantive decision about that. Then the next thing that came up before we even got to, or right after SEAL Team 6, was Judge Henderson, who would have been the only vote I would have thought maybe would go with him. She was the one that had voted to delay the oral argument. She was outvoted 2-1. That's why it happened today. But she wasn't buying anything that John Sauer, the lawyer for Donald Trump, was selling either. And she said, look, even in your main case that you're citing, which is Marbury versus Madison from 1803, a case that you and I spent weeks on it, weeks in law school learning Marbury versus Madison from that seminal case. She said, even there, the distinction is between official conduct of a president and ministerial conduct of a president. Put aside personal, private conduct. And don't we have to kind of make that decision first to even find if he's within the scope of his official acts? Now, she raised the issue, maybe it should go back to Judge Chutkan at the trial level, further delay, to adjudicate whether this is inside or outside these official acts. But I agree with you, Ben. I saw your commentary. I don't think they're going to do that. I don't think it's going to go back to Judge Chutkan. They're going to make a decision. And I think the SEAL Team 6 argument is going to be the one that's going to go down in history as being the most telling, revealing moment during this oral argument. Because, and as I said in a hot take in with you, In Donald Trump's world that he has posited, the one that James Pierce, the lawyer for the Department of Justice, is so viscerally reacting to, I don't want to live in the world where the president of the United States could order the assassination through SEAL Team 6 of his political rival, and there is no criminal justice remedy for that. I actually said, what if the crime were committed, which is what happened sort of here, so late in the term, right before handover to the next president, like minutes. But what if he committed the crime 5 minutes before Joe Biden's swearing in? Everybody would agree there's no time for impeachment through the House or conviction through the Senate. So what do? The guy just gets off scot-free based on timing? Because their major argument, Sauer, the lawyer for Donald Trump, kept pushing time and time again, is you have to, this must be their lead argument, you have to have impeachment and a conviction. And if you don't get a conviction at the Senate, then you could never have a criminal process convict him. And first of all, that is a complete misreading of the Constitution and the requirement. And that's, you have to lop off half of the language from the impeachment clause. Impeachment is all about removal from office and or disqualification from office. It has nothing to do with indictment, imprisonment, or sentencing. And that's what the provision says. So they've turned it on its head and said, well, he had an impeachment, but he's never convicted. If he was never convicted, you can't bring a criminal case. That is not what it says. And the judges today were not buying the impeachment argument. And they're troubled by whether they have jurisdiction or not. At the end, I'll just wrap it up this way, Ben. They are going to, as we think, they are going to rule against Donald Trump. I think it'll be 3-0. I don't think it goes back to Judge Chutkan for anything. And then the loser is going to have to try to take an appeal through a emergency writ up to the United States Supreme Court.
Couldn't agree more with you there, Popok. I think that it will be on jurisdictional grounds while signaling, if for whatever reason they're reversed by the Supreme Court on their jurisdictional decision to reject the case, they will then immediately go to the substantive issue and reject it on the grounds that, to your point, no, in the United States of America, we are not okay with presidents having Navy SEAL Team 6 kill their political opponents and then claiming absolute immunity. And Popok, you give the example of, well, if a president engages in these crimes right before they leave office, then there's not enough time for an impeachment. Therefore, under the Trump theory, you can't go through the impeachment in the House, conviction in the Senate. Therefore, you're totally immune from the most heinous and despicable acts. The example in that audio clip that we played earlier in this video was, what if the president orders SEAL Team 6 to kill a political adversary and then, before an impeachment can take place, resigns the way Nixon resigned, so there is no possible impeachment at all? Then you're immunized for the conduct, to which the judges then said, but when it came to Richard Nixon, if that was the case, why did Nixon get a pardon if he thought that he was absolutely immune under your conception of Marbury versus Madison? Because clearly Nixon didn't think that he was absolutely immune.
Let me ask you a question on that. Sorry to interrupt you. Let me ask you a question. How did you take when Judge Pan mentioned the congressional record and the statements that were made by the then president, that he was Trump at the time, that he was not immune to criminal prosecution after he left office, as being a basis for why certain senators, including Mitch McConnell, did not vote to convict at the time of the Senate, and putting John Sauer back on his heels about positions taken in the congressional record by the President Trump at the time that is completely contradictory to the positions they're taking today in the appeal?
You know, hearing the difference between the two lawyers, I mean, both in terms of tone, structure, arguments, was night and day all around. You know, Trump's lawyer, you kind of get the lawyer you deserve. I mean, just hearing the arguments that he would make, it just kind of it kind of almost is like where you're arguing with like a third grader who, no matter what, has some excuse about why it wasn't them who did what they're being accused of, and they'll come up with everything over and over again, but like it doesn't make any sense actually at all. So John Sauer, who I think you said sorrow because it's a sorrowful argument, because it was a lot of woe and sorrow that I saw there as well. It was a very, he had no comeback to it. And whenever he would kind of get pinned to give a yes or no answer, what he would do always is go back to Marbury v. Madison, just give a name of a founder, and then, you know, try to throw in a big word or two. And for a lot of our listeners who were saying like, hey, can you help us break down, like, what was he saying? Like, it was just a bunch of word salad garbage. There's no support for any of his positions in Marbury versus Madison. The founders never said what he claims they said. And he was just saying that every time he was kind of pinned, I guess the way a boxer, you would think about it, would kind of duck from being punched when they're against the ropes, he would just go back to Marbury v. Madison. But it was a great point when Judge Childs, Popok, said the argument that you're making, that you have to go through impeachment and conviction in order for there to then be a criminal charge that is brought. You're aware that was the exact opposite argument that Trump made during impeachment, saying, don't impeach because that's for the criminal process to take place later.
This is where, and you and I have been advocates at appellate level, this is where he lost basically in the first 5 minutes any credibility with that panel as an advocate. You always have to maintain your credibility. You may not like the hypothetical that's being presented to you by the panel. I often don't. Because it goes right to the heart of a weakness in your case, but you have to concede it at some point and then try to explain around it. And his way to try to explain around it only made it worse and made him look ridiculous. He said at one point, which is a lift from his brief, there is a long, uninterrupted chain of precedent that presidents, after they leave office for things they did while they're in office, cannot be criminally prosecuted. And he was interrupted. I'm sorry. There is, you agree with me then, sir, there is not binding precedent about this very issue, about presidential immunity for crimes. That's why we're here, right? He says, well, yes, but it's an unbroken chain of no president ever been prosecuted. That's different. That is likely more the result of we've never had the level of criminal president like we've seen with Donald Trump, right? The kleptocracy in action. That's not because there is some constitutional limitation. You know, when they brought up the pardon issue, Judge Pan gave a couple of examples. Let me give you some examples. You tell me whether this is something that has to go through the impeachment process prior to a criminal indictment or not. SEAL Team 6 ordering them to kill a political rival. Conditionally, yes. I'll put you down for no. I'll put you down for that president cannot be criminally convicted if the Senate doesn't convict him. Okay, you agree? Yes, he finally had to agree. Now let's go to how about selling pardons? That's an official act. He's allowed to give pardons. What if he sells them in exchange for money? And the first thing out of Sauer's mouth was, oh, like in the Clinton case with Mark Rich. Like they're always ready because at bottom they are so MAGA extreme. And John, we'll do a separate hot take, you and me, or we'll talk about it on the weekend about John Sauer's background. You know, he's testified to the MAGA House about, you know, all these types of conspiracies relating to Biden. I'm sure he's going to be involved with Hunter Biden and an impeachment process. He's that guy. You know, don't be fooled by the fact that he double talks at hyper speed with a voice that's almost unlistenable to. I'm glad we weren't watching it. I made a joke to you guys on the text chain. I said, this guy's voice is like the love child of broken glass and sandpaper. I mean, I don't know what happened to him today, but he was almost unlistenable to. But if you really listen to the guy spouting out, as you said, founding fathers and this provision, that there's no there. You know, he ignores all the precedent leading up to this moment, such as never got mentioned here, never got mentioned really in his reply brief, which is the Cy Vance case, Vance versus Trump, which has his own client's name in it from 2020. That's one of the leading cases about criminal process being used against a president, in which the Supreme Court 7-2 voted that a criminal subpoena could issue to a president, a former president, about his time in office, and he had to. He was still president, and he had to respond to it. But he doesn't like that link in the chain that leads inexorably to a decision that will be against him. So he keeps talking about an 1803 case of Marbury versus Madison, which is primarily for the proposition that the United States Supreme Court is a co-equal branch of government and can review the actions of other branches of government. Yes, it had some commentary about the president's role under Article 2 and all of that, but that is not the gravamen of Marbury versus Madison, although that seems to be, his life preserver, as he was taking on considerable water from the beginning. I don't think his jurisdictional argument was very convincing, and his answers to the SEAL Team 6 example, which go for Judge Pan searingly right to the heart of where they're going to write that decision against him, he had no answer, because he can't answer that question honestly. First of all, he's got Trump sitting behind him in the room. Second of all, the way they briefed it, he had to go down with the ship, and go down with the ship he will.
Michael Popok, thank you for the summary. Hope everybody also enjoyed our live coverage. Make sure you're subscribed to the MeidasTouch YouTube channel and to the LegalAF audio podcast. A lot of legal developments are right around the corner. There will be a lot of breaking news. Make sure you hear it first with all the facts in context here on the MeidasTouch Network and LegalAF. Thank you, everybody, for watching. Shout out to the Meidas Mighty.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.